Showing on Law Weekly today, another perspective on electoral reforms. We look especially at the link with judicial outcomes. We have the views of Senior Advocate of Nigeria, Robert Clark. Some judicial stability in Cross River State as Governor Ben Ayade finally swears in Justice Akon Ikpeme, making her the second female chief judge in the state's history. Plus our recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shayeli. Last week on the show, we brought you the views of Senior Advocate of Nigeria, Kunle Adegoke, on constitutional amendments and possible areas for electoral reforms. This week, we have another perspective, especially on the link between the judiciary and election outcomes. I sat down with Senior Advocate of Nigeria, Robert Clark, to get his views on these and other issues. He believes that the country needs a brand new constitution as opposed to a constitution amendment.
As I've always explained, the 1999 Constitution is a rotten egg. It needs to be jettisoned and a new constitution. So no amount of amendments can rectify that rottenness, is it? The Yoruba say, Odongbodoru. Once you are amending something that is rotten, you can get nothing out of it. Because the way and manner it is done makes sure that we can never make any headway.
So what would you have the lawmakers do instead?
I have always said it. We don't need to advise. Buhari should do what Jonathan did in 2014, set up a national conference, but before setting that national conference, he should send a bill to the National Assembly that I intend to call a national conference to let the country know what type of constitution we should now have. We need a legal backing to call that conference, which Jonathan did not do. That was the mistake Jonathan did. By the time they finished the conference, they discovered that there was no legal basis for it to have even been started. So when he gets that legal backing, he will ask members of Nigerians in various ways, bring them to Abuja, draw up a new constitution for us. When that is done, he now takes that constitution, makes it as a referendum, that look, this panel has done this for Nigeria. Do you want it or you don't want it? If it's a parliamentary system of governance, if the president, then the Nigerian people will say, yes, we prefer this or this. The benefit is that once the country speaks, Buhari will now send the result of the referendum to the National Assembly, where their hands have been tied from the beginning that they have to approve it. Because if you don't do so, the crop of people we have in the National Assembly will never change the concept of the Nigerian Constitution because it benefits them. And they will never agree to change the Constitution except in the manner I've suggested.
Why do you say it benefits them?
You know how many allowances they get? You know what salary? They will tell you they are on such and such salary, whereas the allowances. Let me tell you a funny story. I had a friend who was a senator. As soon as he came in about 10 years ago, the first thing they did, all the banks started sending him overdraft facilities for 100 million. That's what the banks are still doing till today. Any new member of the Senate, the banks will grant them 100 million. Where do they think they are going to get? Because they know the amount of allowances they get, covers this. The banks will not loan you money without any security. So these are the things why the National Assembly cannot and will never change this constitution. They will continue to amend a rotten egg and nothing will come out of it.
So this new process has to be driven by the people?
It has to be driven by, because even when you look at the 99 Constitution, they will tell you, we the people of Nigeria. That's a fallacy. Which are the people who, it's the military and some top Nigerians who are in a circle of, governance in Nigeria.
So let's talk about electoral reforms as part of the constitutional amendment process. Many Nigerians are very worried about the link between the judiciary and election outcomes. It would appear that in a lot of cases, some election outcomes have been determined not by votes, but by the courts. And the situation in Imo and Bayelsa states and a lot of others readily come to mind.
Now, let me be honest with you. We have problem in Nigeria. Most of the election processes in this country have been, placed in a way, and I'm sorry to say this, it is the judiciary that benefits. I am sorry to say it, but this is what I know. Let me give you examples. When the 1999 Constitution was created, presidential elections emanating from the Court of Appeal to Supreme Court was the only constitutional matter that was allowed to go to the Supreme Court. Things were going smoothly then because only once in 4 years you will disturb the process of the Supreme Court. During the period, my good friend, late Katsina Ali was there, and Salami, who was the president of the Court of Appeal, there was this rumor in Sokoto election that money was being, given to change hands, talking in terms of billions of money. My good friend Katsina Ali believed it, made inquiries, and decided that Salami should stop that election judgment being given. And of course, Salami told him, you are the Chief Justice of Nigeria. I am the President of the Court of Appeal. Our lines are different. You cannot dictate to me, which was correct. Now, when they discovered that money was flowing, and international reports shows that the judiciary in Nigeria is so corrupt, when they themselves realized, Katsina Ali and some of his now made the National Assembly to amend to show that every election petition, the Senate, the gubernatorial, must end at the Supreme Court. That is where, as I use my friend's language, fella, scatter began. Look at the last gubernatorial decisions. Let me take, as you've rightly said, Bayelsa, whatever. But the most outstanding one that I will always remember until I die is the Zamfara case.
Because you were involved in that one.
I was involved, and it pained me, and I wept when the Supreme Court was reading a judgment because there was a minority judgment in my favor. This is a case that came to the Supreme Court not as an election petition, but as a pre-election petition. 5 members sat, and when they found that the appeal has no merit, they now decided to sit as INEC and awarded the election to the next, according to them, PDP. In law, they had no jurisdiction. They know it. So what I did was to say, look, you have exceeded your powers. This matter was not brought to you as an appellate jurisdiction of Supreme Court. This is a pre-election matter. You have no right. Professor Sagi wrote an article supporting my stand. But what did you get? I got to the court what I never canvassed for. The opposing lawyer now said I was challenging the right of the Supreme Court to alter his judgment. When clearly I told them I was not challenging your judgment. I am challenging the consequential orders you made. One of the judges saw my point and wrote a very interesting judgment. And that I was correct and that the Supreme Court was wrong, but it was 4 against 1. The funny thing is that 5 judges who sat in the Supreme Court, 3 of them were in the same panel that gave the other judgment. Normally, they should have excused themselves. The CJ was there, and Ariwola was there, and Okoro was there. And they jettisoned my argument and said I was challenging the jurisdiction of the judgment.
For those who don't understand, maybe you should put names to it so that we can understand this Zamfara judgment that you're talking about.
Zamfara judgment was because APC had problems in Zamfara, so there were 2 competing primary elections, one being held in Abuja and one being held in Zamfara. Now, INEC says, look, we will only accept the one that court says is correct. So APC in Zamfara went to court, and they got a judgment that our own primary is the correct one. So INEC cleared all their candidates, made them to contest election, gave them returns after the election. Now, that judgment of the Zamfara now was appealed against by PDP, or internal rift within APC, and then the Court of Appeals says that primary in Zamfara was not the correct one. The Court of Appeal now, the judgment was appealed to Supreme Court. It's a pre-election matter. It's not an appeal from this thing. The Supreme Court, yes, we endorse the Court of Appeal this thing, but we have to teach you lessons that you politicians, we must follow the law. Therefore, we will order that everybody who contested on APC ground has lost. And the next man should be, that is travesty of justice. They had no jurisdiction. And the problem now is that the better if we are doing a cover-up for our election regulations, we have to look into such areas. At what stage can the Supreme Court assume the position of INEC and dictate who or who should not be a candidate? They don't have that power. The power who should be a governor or senator resides with the people. And if you as a court discover something is wrong in that, send it back to the people. Let them go and revote, rather than declaring, like in a Bayelsa case, that the deputy governor had no qualification, or, Imo case, it is not the right for any court to do that. That is one area I will urge that all appeals, even if they get to the Supreme Court, which I don't want them to get there, must be returned back to the people to decide, because the power belongs to the people.
Is that something that legislation can cure?
You see, before you can legislate against court rulings, you must make sure that the system is free of fraud, is free of corruption. But unfortunately in Nigeria, corruption permeates every stage of our election. And therefore, you will see corruption rearing its head, either in the counting place or in the ballot place. And until we get ourselves as to the mode and manner we conduct elections, we will also always be caught by the court coming in at the last stage. So we have to look at the mode and manner the system should be allowed to conduct elections. Electronic, data, whatever. Let them look at what is happening in the world today. There are many African countries that have held elections, and you don't find election petitions flying here and there. You don't find pre-election this thing that go up to the Supreme Court. These are areas the National Assembly should look into and remove all the risks of litigation away from them.
The card readers, is it time to legislate on it as part of the election process? Because I asked that question because it wasn't recognized by the courts the last time.
It is the argument that the law did not provide for the use of card reader. This is where I'm saying that you don't need to allow such a matter to get to the court, because judges will have 3 judges, and they think differently. The fact that a card reader did not work or worked and is not provided for by law does not mean the election is a sham. So these are the things we have to look into in Nigeria.
Also, the call for creation of an election offences tribunal with specialist judges. Any merit in such calls?
There is no merit if we as Nigerians believe Nigerians are going to cheat at an election, and therefore we have a court. It does not speak well of us as Nigerians. It means from first day, we know people will commit it does not speak well. Let us believe that Nigerians will behave. But unfortunate Nigerians are a special species of people. They do the wrong thing. They see how they can evade the law. So for that purpose alone, we have been voting in Nigeria now, say, for 20 years. I've never seen anybody convicted in Nigeria for this thing. So if you want to make a law that will be, obeyed in its disobedience, why do you go by it? But for whatever argument you want to, for those who want it, I would say do it. But it does not solve our problems. You see what is happening in America today? You see what happened in Georgia when the president of America was phoning the governor and says, look, I need 11,000 votes from you. And they are in the same party. And the president was telling him that if you don't do it, you know the consequences. But they stood firm. They stood firm. That is what we are praying for in Nigeria. That is what we want.
Welcome back. Let's go all the way to Cross River State now, where there finally appears to be some stability in the judiciary with the swearing in of Justice Ekon Ikpeme as the Chief Judge of the state. It didn't come easy, especially as she had twice been rejected by the State House of Assembly because she's not from that state. In this next report, we have the highlights from the swearing-in ceremony.
Members of the judicial arm of Cross River State gather at the executive chambers of the governor's office in Calabar, the state capital. They are here to witness the swearing-in of Justice Ikpeme. Reacting to a confirmation, the governor, Professor Ben Ayade, describes Justice Ikpeme as the most qualified professional for the position. He seeks her support for a robust working relationship.
Today brings to a close the internal concerns and worries of the people of Cross River State as to the stability of our judicial system. I believe by the infinite mercy of God, God has chosen for Cross River State not just a person to be the chief judge, but a woman. Not just a woman with great conscience, a woman of God, a leader of the church, and a convenient child. I believe in a thanatological philosophy that you must put behind all the challenges in the process of getting back here and to know that God has prevailed and God's way has been and I've, in the course of time, had a very close relationship with her. Throughout my discussion, it appears to me very clear that she is here at the right time and she's the right person for this job.
The newly sworn-in Chief Judge, Justice Ikpeme, assures that the judiciary under her watch will collaborate with other arms of government to bring about good governance for all, irrespective of where and who they are.
The people and government of Cross River State should expect that by the grace of God, we are going to move the Cross River State Judiciary forward. Like I discussed with His Excellency, there are areas we need to really catch up on, and we intend to do that. I don't want to go into specifics, but I have those areas in my mind, and I pray that by the grace of God, before my tenure is finished, we will advance in those areas. That's my prayer.
In his remarks, President of the Nigeria Bar Association, Olumide Akpata, expresses delight at the occasion, describing it as a climax to a long struggle.
For us, it is a very fitting climax to a long process. You see, in life, the problem is not that there are challenges. It is how effectively we are able to resolve these challenges that really is the hallmark of leadership. So I'm glad that between all the dramatis personae, we have been able to come to this very fantastic outcome. This outcome that reflects the intent of our Constitution.
Other members of the executive arm of the state government also expressed their pleasure with the development.
We thank God. We pray for her. We pray for the state that in this era, at these difficult times, they will be able to steer the affairs of the state and the judiciary especially in the right direction, that justice may flow in the state and that the judges of the state will be able to dispense justice effectively, efficiently and in a timely manner.
I wish the new Chief Judge a very wonderful tenure in office, and I know definitely that issues in Cross River, legal issues in Cross River State will really be well handled, because we are putting a square peg in a square hole, as a matter of fact.
Justice Ikpeme succeeds Justice Michael Edem, who retired in November 2019.
And on the home stretch, we bring you a recap of some of the activities from the courtrooms.
We begin with the report that the Federal High Court in Abuja has ordered the Central Bank of Nigeria to unfreeze the bank accounts of 20 NSAS promoters. Justice Ahmed Mohammed gave the ruling following the agreement reached by parties in the suit to amicably resolve the matter. The judge, while commending counsel to the CBN, Mr. Michael Aunduaka, and lawyer to the defendants, Mr. Femi Falana, ruled that all processes filed in respect of the case are deemed to have been withdrawn. Justice Mohammed then set aside the November 4, 2020 order and ordered that all the accounts of the affected persons be immediately defreezed. The CBN, in an ex parte motion, had prayed the court to freeze the bank accounts of Bola Tito Rachel Odwala and 19 others who participated in last year's protest to end police brutality in the country. The Apex Bank said it took the action to investigate the promoters of the protest on allegations bordering on terrorism financing, among others. Still in Abuja, the Economic and Financial Crimes Commission is set to arraign a former Minister of Aviation, Senator Stella Udua, at the Federal High Court Abuja for alleged financial impropriety. Justice Inyang Ekwo fixed the 22nd of February for the arraignment because the former minister was yet to be served with the court processes. Senator Udua, who currently represents Anambra North Senatorial District at the National Assembly, is facing the fraud charge alongside 8 others. The same Federal High Court in Abuja has ordered that the rearraignment of former Abia State Governor Senator Orji Uzor Kalu on an alleged 7.1 billion naira money laundering charges be put on hold pending the resolution of the legality of the retrial charges brought against him by the Economic and Financial Crimes Commission. Justice Inyang Ekwo, in the ruling on an ex parte application, also granted leave to the senator representing Abia North to challenge the legality of the retrial in the same charge. The judge admitted that Senator Kalu, who is the Senate Chief Whip, had placed sufficient materials of value before the court to enable him secure permission for judicial review of his retrial in charges in which he had been tried, convicted, and spent some months at the Kuje prison in Abuja. Justice Ekwo, who announced that the order of the court shall operate as a stay of proceedings, also granted Senator Kalu permission to apply for an order of perpetual injunction against the federal government through the EFCC to prohibit his retrial so as not to be made to suffer double jeopardy. The court subsequently fixed February 23, 2021 for mention of the case. In Lagos, the Federal High Court has fixed April 13th for the hearing of an application seeking the final forfeiture of the sum of $5.8 million and another 2.4 billion naira said to have been illegally acquired by former First Lady Dame Patience Jonathan. Justice Chika Obiozor fixed the date after lawyers involved in the matter appeared before him. Lawyers to the defendant, Mr. Ige Ashimudara, has also submitted that the matter ought to commence afresh since it's before a new court. Justice Obiozor held that he would proceed with the hearing of the application for final forfeiture on April 13th. And we round up with the report that hearing has commenced afresh at the Uyo Magistrate Court in the case of alleged sexual abuse, starvation and negligence instituted by the parents of Don Davis Archibong, an 11-year-old student of the Deeper Life High School Uyo campus, against the school principal, some staff and 2 students. This was necessitated by the sudden transfer of the magistrate hearing the case. He has since been replaced. As usual, since the commencement of the case, the media was barred from observing the proceedings. 7 accused persons are facing a 4-count charge bordering on sexual molestation, maltreatment, starvation, and negligence. The case has been adjourned to March 3rd this year.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shirley. Thank you for watching and see you next week.